Welcome once again to Lehto's Law. Here's Steve Lehto.
I did a series of videos earlier about the city that had seized some money under civil asset forfeiture. And the guy whose money it was went to court and fought it, and a judge said, give the man his money back. And the city said, oh, we can't. We've passed that along to the federal government. They've got his money now. And the judge said, I'm not kidding, give him his money back. And the city then said, no, we're not going to do that. And so what happened then was nothing. And people said, wait a second, Steve, if I was ordered by the court to do something, I would do it. And if I didn't do it, bad things would happen. So when the city of Mooresville doesn't do something after court tells them to, why didn't bad things happen? Well, what happened was the action was moved to federal court. Ryan sent me a note and said, Steve, did you see what happened in federal court? And I admit I'd missed it. And he goes, here's the link. And he sent me the link. And I'm going to tell you right now, this is going to be a long video, because we're going to go through this process so you can see the insanity that is civil asset forfeiture. Because I've mentioned before that there's so many things wrong with it that most people, when they see how it works, go, that doesn't make any sense at all. But it's in court, and this is what happens. So, for instance, the lawsuit is entitled United States versus $16,761 in U.S. currency. The man whose money was stolen is not a party to the case, technically speaking. This is a lawsuit between the government and the money. They actually created this legal fiction centuries ago that the government can sue physical objects. So if the government wanted to, it could sue this widget. It can sue the money. And so the action is entitled United States versus $16,761 in United States currency. Now, this matter is before the court. I'm reading directly from the court order here, so I'm not making this stuff up. This matter is before the court on claimant Jermaine Sanders' motion to dismiss, motion to strike, and request for judicial notice. And what happened was that this action got started, and the claimant is the man whose money was taken. And so the court recognizes that the person who was associated with the money should be allowed to make an argument that the money is theirs or that the money is innocent of all wrongdoing. And so he did that. So the court says, here's the relevant background. In November of 2020, Jermaine Sanders' rental vehicle was searched by law enforcement after they said they smelled marijuana, and a certified drug detection canine positively detected the odor of narcotics on the vehicle. It's a rental vehicle. And I don't know if I need to explain to you what a rental vehicle is. I've rented a few in my life, and I've gotten in a rental vehicle before that had strange smells to it. And also, I'm not responsible for what happened in that rental vehicle an hour before I got into it, because something else might have happened in it. So to suggest that a rental vehicle's got strange smells that we can attribute to this man is already a stretch, and we're only in the first sentence of the facts. Law enforcement then searched the car. They did find marijuana and $16,761 in currency. I'm simply going to refer to that as the cash from now on, because that's a long, long number to pronounce. Officers of the Mooresville Police Department arrested the man and charged him with state drug offenses. On November 17th, 2020, a detective contacted Department of Homeland Security Investigations, and a task force officer, and requested that HSI take over the investigation of the currency. On November 19th, 2020, Sanders filed a motion for personal property to be released to defendant. So while the state is working out with the feds what's going to happen with this money, this man filed his state action and said he wanted to get his money back. And so that was a case that was filed. On November 20th, 2020, one of the officers notified the Mooresville Police Department that DHS would investigate the currency and that the MPD should follow standard protocol for turning the money over to the DHS. On November 23rd, one officer met with the Mooresville Police Department detective Sean Elliott, who signed out the currency, converted it to a certified check to U.S. Customs and Border Protection, and delivered the check to TFO Powers, who then delivered the check to CBP in Charlotte. By the way, one of the things we discussed was The Mooresville Police Department said we can't give the man his money back because we gave the money to the feds. They didn't. They gave the feds certified funds. They still had the cash, or they converted the cash. If we're actually putting the cash on trial, can we launder it by putting it through a bank and turning it into certified funds that are then gone? Because remember, the fiction is that this thing here is on trial. So if I get rid of that thing and bring in a duplicate of it and put that duplicate on trial, what about that thing? I mean, if a person is on trial, the state versus John Doe. John Doe can't skedaddle and go, I'm sending in another John Doe in my place. No, you put the person on trial. You put the thing on trial. You put the cash on trial. So they admit that they converted the money to a certified check and delivered the check to TFO. So when the Mooresville Police Department came into court and said, we gave the money to the feds, it's not actually true. They gave the feds a check. Do we put the check on trial? Or do we have to go now and find the money that's out in circulation? The money has become fugitive. So following the relinquishment of the currency to feds, the state court ordered the return of the currency. However, in doing so, the state court order did not hold or assert that it was exercising in rem jurisdiction over the currency. And in rem jurisdiction is when they talk about taking something under the jurisdiction of the court versus taking jurisdiction over a person. There's personal jurisdiction and in rem jurisdiction. It's Latin. But subsequently, Sanders' counsel emailed the state court's November 24th order to the Mooresville Police Department and a state assistant district attorney asking how the funds would be returned. She was told to contact the feds. And because the federal government had adopted the currency, and yes, that's the term they use, they say that, well, the feds didn't seize the money. Mooresville seized the money. But Mooresville turned the money over in the form of a check to the feds who adopted it. So the feds didn't seize the money. They adopted the money. I'm surprised there's not an adoption order somewhere in here. The federal government had adopted the currency. Then the attorney filed a verified motion to show cause, asserting that the police department was out of compliance with the state court order. The Mooresville Police Department responded in opposition, and on January 26, 2020, the court issued an order on verified motion to show cause, which found probable cause to hold the Mooresville Police Department in contempt for not turning the money over. So they had a show cause hearing. The state court issued an order holding the state court acquired jurisdiction over the cash. The state defense counsel filed a motion for return of property. The state court also stated that despite the Mooresville's argument that MPD had prior to the order turned over the currency to DHS, the town and MPD still had ability to use funds or to liquidate assets at their disposal so as to enable them to comply with the subject order by releasing $16,000 to Mr. Sanders. So they're saying, look, it doesn't matter what happened to the money. They're ordered to give it back. They should give them back something. Whether or not they have that actual money, we don't know. We don't care. More proceedings ensued in state courts, culminating in the North Carolina Court of Appeals issuing a temporary stay of the district court order. Now, the United States filed the verified complaint for the forfeiture, which is this action here. Then the claimant, whose money was taken, filed a motion to dismiss and request judicial notice, and the United States responded in opposition, and the claimant filed a motion to strike the opposition. Neither party contests that the claimant has standing in this case. So they're saying, look, this guy here, Sanders, has the right to be here and fight for this money. The problem, they're saying, is that the money was seized by the city, and then they turned it over to the feds who adopted it. And then when this man went to state court and said, I want my money back, that the state court didn't exert the proper jurisdiction over it, and therefore they weren't in a position to order the feds to give the money back. So, yeah, there's a lot of paper here, sorry. Sanders' motion to dismiss seeks to dismiss the complaint for lack of subject matter jurisdiction. And claimant argues that the county district court has exclusive in rem jurisdiction over the currency, and therefore this court is divested of its exclusive subject matter jurisdiction over forfeiture actions brought by the federal government. Because the court finds that the state court was not exercising in rem jurisdiction, it will deny the motion to dismiss. Federal courts exercise exclusive in rem jurisdiction in forfeiture cases brought by the United States, and there's some case law on this. The United States bring this action under a statute for violation of this and violation of that, 21 U.S.C. this, 841, 846. While the currency was initially seized by state police, the United States may seize drug proceeds without a warrant for the purpose of initiating forfeiture proceedings under several different circumstances. But here's the problem. The feds didn't seize it. The states did. So this exclusive jurisdiction can be divested if the state court had obtained in rem jurisdiction prior to the court obtaining jurisdiction. So the state court needs to get in rem jurisdiction before the federal court gets jurisdiction over the case. I know it's confusing, and I think it's done that way on purpose. Under those circumstances, dismissal of the federal action will be required as only one court can have in rem jurisdiction over a res, which is basically a thing. The court first acquiring jurisdiction or assuming control of the res is entitled to maintain and exercise its jurisdiction to the exclusion of the other. So the threshold issue in deciding the motion to dismiss is whether the court must defer to the state's ruling, the state court's ruling. Now here's the thing. When a federal agency adopts property, you're going to a new home, $16,000 in cash. You're going to a new home in upstate New York. You live on a farm. When a federal agency adopts property, it is as if the agency originally seized it on the date it was seized by the local authorities. Once a federal agency has adopted the property, a state court is prevented from exercising jurisdiction over it. Therefore, from the time the proceeds were taken into federal custody, the state court was prevented from acquiring jurisdiction. The adoption in this case was effective on November 23rd when the currency was turned over to HSI. And again, it wasn't currency, it was a check. Just pointing that out as if it matters. Consequently, an order or statement regarding jurisdiction issued by the state court after that date cannot operate to defeat federal jurisdiction. Therefore, the November 24th and February 9th orders, both issued after the federal adoption, do not bind the court. So this is bizarre. Like I said before, it's just like verbal gymnastics. They're just like twisting words around and making up sentences and stuff. And one of the things they say, and I'm not going to read all of this because it takes forever. It's 8 pages long, and we ain't got that kind of time, is that they say that the federal government has the right to adopt currency if it was legally seized by a state agency. So the Mooresville Police Department is a state agency. They seized the money, and then they quickly hand it over to the feds via a check, and now the feds have it. So when the state actors get dragged into court and they say, give the money back, they go, we can't, we gave it to the feds. The question is, what right did the state actors have to seize the money? Because the statute that protects the federal government in this situation says that the adoption works only when the state actors have seized the money legally. And the question is, how would you determine the legality of that without litigating it? And the litigation that followed the seizure said the money should go back to the guy. Seems to me that would be an illegal seizure. I've only been practicing law for 31 years. So this is the problem. Everyone knows that the state agency that seizes money and turns it over to the feds gets a slice, a commission. And the feds, when they get it, will pay that slice off and just keep the rest if they can. But what's going to happen here, most likely, is this is not a final order. This does not dispose of the case, as we say. What's happening now is this man has to relitigate his case in the federal court. And we are fighting over $16,000. Now, again, I know that the vast majority of my audience is not lawyers, but to litigate a case as this was litigated in the state courts successfully up to the end, and then to relitigate everything all over again in the federal courts is going to cost more than $16,000. And they know that, and that's why they do this. So one court already said, give the man his money back. And now a federal court saying, oh, that state court didn't have the right to say that. They had the wrong jurisdiction. But this is all teetering on a very, very weird premise. Because remember, when they're doing the civil asset forfeiture, and remember the name of the case, the United States government versus cash in a dollar amount. The cash is on trial, but the cash escaped a long time ago. The cash was dissipated by the Mooresville Police Department. They didn't have the cash. The cash can't be put on trial anymore. It's gone. They converted the cash into a check, which was then sent to the federal government. So it seems to me that somebody should look at this and go, well, wait a second. If we're putting this on trial and it's not here anymore, isn't this all moot? And then the man can say, yeah, you owe me damages in the amount of the cash you took from me. I'll take it in any form. I don't care if it's that cash, or you can give me a check. You can pay the guy back in cash, but you can't convert the cash into a check and say, well, we're still putting the cash on trial even though we let it go. So it's a crazy case, and I still think civil asset forfeiture is one of the craziest things in the legal system. I apologize for it. It's not my fault, but as an attorney licensed to practice law in the state of Michigan, I do feel the need to occasionally tell people who are not attorneys there are problems with the legal system, and on behalf of the legal system, I now apologize to you for it. I'm doing what I can to educate people on this, get the word out, let people know. But as of right now, the Mooresville Police Department is out of the picture. The federal government, who adopted the check that represented the cash, they're now prosecuting the case against the currency, and Sanders is a claimant in the case now in federal court, and he's certainly beyond $16,000 in legal fees. I'm sure he is. So Ryan, thanks for sending it, but there's your update on what's happening in Mooresville. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Instruction does much, but encouragement, everything.